Hi, I'm attorney Sean Palmer, and on today's Texas Family Vlog, we're going to talk about modification suits that are brought just to harass you. Hi, just a short little vlog today because, as you can see, I'm on vacation. But I did want to get a vlog out today, and the topic is one in which many people may be interested in because we're always worried about going to court. Court is not fun. That's why you get an attorney. But you need to know some facts. So your family court case is over. You got a final decree, whether it's a divorce decree or a child support and custody order, your case is over. But you still have your ex-spouse or the mother of your child or the father of your child threatening you with a lawsuit to modify the case. Modification in Texas is allowed in cases where you have a court of continuing jurisdiction in which the child is the subject and you are under orders. After usually a 2-year period, the court will start to entertain changes to your plan. We call that modification. But you might have a situation, a high conflict situation, where your ex-spouse or the mother or father of your child are threatening you to modify the order that you work so hard to perfect and is working for you. If the purpose of the suit is for harassment or there is no legitimate reason for the suit, the courts don't take kindly to people who are using the court system as a way to harass the other party. And so there's some very strict rules on that. And if your party on the other part is threatening you with suit, you might want to mention a couple things that we have here in Texas. The first thing I'll mention is that under 156.005 of the Texas Family Code, if you have to go to court and defend yourself against a useless suit, or what we call a frivolous suit, the court must award you attorney's fees if you can show that the case was groundless. And now that's important. Must. There's no discretion by the judge as to whether the other party in the case has to pay for your attorney fees if the case is just brought for harassment. The second thing is that also under 156.005, the court can issue sanctions if there is a finding that the case was brought for the sole purpose of harassment. These sanctions will take the form of a money award, and it's a further disincentive for the party to bring a frivolous lawsuit. Finally, the court can also award sanctions under Rule 13, which means that not only can you be sanctioned for money for filing a frivolous lawsuit, but your attorney can as well. So, if you're the victim of a frivolous lawsuit that's brought for the sole purpose of harassment, you might get sanctions under Rule 13, not only against the party, but also for the attorney for allowing this frivolous lawsuit to be filed in the first place. So in summation, if you are the victim of a lawsuit that is brought to modify a child support order, child custody order, and its sole purpose is to harass you, and it is what we call a frivolous lawsuit, then you might be able to get from the other party attorney's fees, court costs, and sanctions. The court, however, will give a lot of generous weight to the other side. We don't want to limit people's access to justice, and we want to make sure that grievances are being settled in court. But if you can prove that there's the case brought to modify is completely groundless, these are some of the options you might have. You might want to talk to a lawyer about those things.